Tonight, we begin with a development that immigration attorneys, civil rights advocates, and constitutional scholars had feared, predicted, and prepared for. A wave of enforcement actions that unfolded not over months, but in days. Days that left families separated. Days that left communities paralyzed with fear. Days that changed the lives of thousands who had no idea what their rights were. What ICE did this week crossed a line that many legal experts had hoped would hold. And when that line broke, communities did not hesitate. They responded with knowledge, preparation, and constitutional power. Because here's what ICE doesn't want you to know. You have rights, powerful rights, rights that can stop them at your door. And tonight, I'm going to tell you exactly what those rights are. And the one phrase that, according to verified immigration lawyers, can legally force ICE agents to leave your property. This is not theory, this is constitutional law. And by the end of this video, you will know exactly how to use it. For months now, there had been signals, not official announcements, not press releases, just signals, that ICE was preparing something unprecedented. ICE has been aggressive, yes, but they have been predictable in their aggression. Their raids have followed a certain pattern, a rhythm, almost a routine. But what set off alarm bells among immigration lawyers this month was that the pattern went silent. Advocates who monitor enforcement activity know the indicators: the increased vehicle presence near courthouses, the unmarked cars in residential neighborhoods, the plainclothes officers asking questions at workplaces, the sudden uptick in voluntary interviews. All of that went quiet. And whenever ICE goes quiet, it means something is about to get loud. Reports began surfacing from communities across the country. Agents showing up at homes at 6 a.m., knocking on doors, demanding entry, using fear and confusion to gain access they were never legally entitled to. And here's the tragedy. In case after case, people opened their doors. They answered questions, they let agents inside, not because they had to, but because they didn't know they didn't have to. That ends tonight. Because what I'm about to share with you is the information that ICE agents hope you never learn. Early this week, civil rights organizations detected what they described as a coordinated enforcement surge, including home visits that had not been conducted at this scale in over 3 years. These are the kinds of operations that ICE only deploys when they are signaling something very specific: deterrence, intimidation, or a test of community preparedness. Advocates didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that ICE was changing tactics. And when a federal enforcement agency shifts strategy without explanation, even by small degrees, constitutional lawyers pay attention. Here's what they discovered. In the majority of cases, ICE agents did not have judicial warrants. Let me repeat that. They did not have warrants signed by a judge. What they had were administrative warrants, documents signed by ICE officials themselves. These look official. They have seals, they have signatures, they look like they carry legal weight. But here's the truth that changes everything. An administrative warrant does not give ICE the right to enter your home. Only a judicial warrant, signed by an actual judge, gives them that authority. And according to immigration attorneys across the country, the vast majority of home visits are conducted without judicial warrants. Which means one thing: if you know your rights, you can legally refuse entry. The guidance issued by the American Immigration Lawyers Association this week was not normal. It was not routine. It was not symbolic. It was urgent. Attorney after attorney described ICE's recent tactics as coercive, deliberately confusing, and perhaps most importantly, legally vulnerable. Because here's what they want you to understand: ICE's strategy only works if you don't know your rights. But if you do know your rights, they must leave. That's not my opinion. That's constitutional law. The Fourth Amendment protects you against unreasonable searches and seizures. It applies to everyone on U.S. soil, regardless of immigration status. Here's what we know. Within seconds of an ICE agent knocking on your door, you have the power to change the entire encounter. You don't have to open the door. You don't have to answer questions. You don't have to let them inside. And if they don't have a judicial warrant, they cannot legally enter. Period. Tonight, immigration attorneys confirmed the exact phrase that activates your constitutional protection. I do not consent to your entry. That's it. 7 words. 7 words that, under the Fourth Amendment, legally prevent ICE agents from crossing your threshold without a judge-signed warrant. Let me walk you through exactly how to use this. Step 1. Do not open the door. ICE agents are trained to get you to open the door. Once you do, the situation becomes more complicated. Instead, speak through the door or through a window. Step 2. Ask this question. Do you have a warrant signed by a judge? Not an administrative warrant, not a deportation order. A warrant signed by a judge. If they say no, or if they hesitate, you say, I do not consent to your entry. Please leave my property. Step 3. Remain silent. You have the right to remain silent under the Fifth Amendment. You do not have to answer questions about your name, your immigration status, or who else lives in your home. Step 4. Document everything. If possible, record the encounter through a window. Write down badge numbers. Note the time. This information can be critical if your rights are violated. Immigration attorneys confirmed that in case after case, when individuals clearly assert these rights, ICE agents leave. They leave because they have no legal authority to stay. This is not about evading the law. This is about knowing the law, and the law is on your side. And here's where the story becomes even more important. Legal analysts now believe that ICE's recent surge was designed to test the preparedness of immigrant communities after years of inconsistent enforcement. ICE wanted to see whether communities would panic, whether they would open doors, whether they would answer questions. But instead, the opposite happened. Communities didn't panic. They organized responses that were so coordinated, so informed, that even ICE officials noticed. You don't get ICE's attention easily. But this week, prepared communities did. Civil rights attorneys speaking with media under anonymity described ICE's shift as pressure testing, a way to identify vulnerabilities. But communities proved this week that they remain both informed and unified. Their responses were not only legally sound, they were executed so precisely that in multiple documented cases, agents left within minutes. That outcome matters because it shows something powerful. It shows that knowledge is protection. It shows that communities are not passive targets. They are active defenders of their constitutional rights. As reports continued coming in throughout the week, we learned more about the scale of community response. In Los Angeles, rapid response networks activated within minutes, forcing agents to leave multiple neighborhoods without a single entry. In Chicago, community organizations targeted misinformation that had been circulating about ICE authority. In New York, legal aid groups operating around the clock reportedly assisted hundreds of families with Know Your Rights information. This wasn't just resistance. This wasn't just awareness. This was constitutional empowerment. This was community defense. And community defense is the one thing ICE has struggled to overcome since these tactics became widespread. For every enforcement surge they have conducted, informed communities have countered with something that changes the equation: knowledge. Remember, ICE assumed communities wouldn't be prepared. They assumed people wouldn't know the difference between warrant types. They assumed fear would override rights. But this week, the exact opposite happened. People asked for judicial warrants. People refused entry. People remained silent. And agents left. What makes this moment so critical and so urgent is that ICE's enforcement surge happened at a time when immigration policy is under intense political pressure. Some factions want maximum enforcement. Others want comprehensive reform. Legal advocates want due process protections. Communities want safety and stability. Enforcement agencies are balancing these demands while operating under conflicting directives. And when agencies in that position make sudden moves, they're not doing it from clarity, they're doing it from pressure, they're doing it from political motivation, which is exactly why knowing your rights matters more now than ever. The ACLU's guidance, now widely distributed, was designed to signal that constitutional protections are not optional. Attorneys said plainly that ICE's tactics were inconsistent with Fourth Amendment protections. That is legal language for they're hoping you don't know your rights. You don't usually hear that tone from civil rights organizations unless something serious is at stake. And something serious is at stake: your home, your family, your constitutional protections. Meanwhile, leading immigration attorneys addressed communities in clear, direct statements this week. They said, you do not have to open your door. They said, you do not have to answer questions. And they said, if they don't have a judicial warrant, they cannot come in. These are not rhetorical flourishes. These are legal facts from attorneys who understand just how high the stakes have become. Here's what makes the situation even more concerning. ICE's latest tactics weren't isolated, along with home visits. Workplace raids also increased in multiple states. Courthouse enforcement resumed in jurisdictions that had seen pauses. Community surveillance intensified, targeting advocacy organizations. All of this happened within the same 2-week period. When enforcement agencies move multiple pieces at once, it means something larger is underway. Legal analysts are now considering several possibilities. One is that ICE is preparing for expanded operations in coming months. Another is that ICE is attempting to create fear that suppresses community activity. A third possibility, the one worrying advocates most, is that ICE is attempting to normalize warrantless pressure tactics. But this week, informed communities took that card off the table. They didn't panic. They didn't open doors. They didn't answer questions. They asserted their constitutional rights. What we're watching now is a test of constitutional literacy. ICE wants to see if communities will forget their rights. Communities want to show they will never forget. Civil rights organizations want to prevent unlawful entries. And families want to protect their homes. Tonight, we've heard from legal aid organizations who are now monitoring developments nationwide. They say enforcement patterns are shifting. They say community preparedness is making a measurable difference. And they say ICE's reliance on warrantless tactics is likely part of a broader strategy intended to maximize compliance through confusion. But communities are not confused. In fact, communities are more informed than ever. Their response this week, swift, legal, and unified, sent a message to ICE that constitutional rights will be exercised. And it sent a message to families everywhere that protection is possible. As the coming weeks unfold, we expect more details to emerge about what exactly ICE hoped to achieve. But what we do know is that community preparation was effective. It prevented unlawful entries, it protected families, and it demonstrated the power of constitutional knowledge. What happens next will depend on what communities do in the coming months. If they continue learning their rights, this moment will be remembered as a turning point. If enforcement escalates, communities have already shown they are ready. They have shown they know the law. They have shown they are ready to use it. And tonight, for the first time in years, ICE appears to be recalculating. Some neighborhoods are quiet, too quiet. And when ICE is quiet, it means they are reconsidering. It means they are realizing something they have learned many times before. Informed communities cannot be intimidated. Constitutional rights cannot be ignored. And 7 words can change everything. I do not consent to your entry. This story is far from over. But tonight, one thing is clear. Knowledge is protection. Rights are power. And you now have both. Share this video with everyone you know, and we will be here, watching every detail as the next phase unfolds.